There are some Democrats who have been at this level. If this is a 10, they've been at a 10 for a while now. But there are some people, and I think one of them is the person that Ezra Klein was talking to in that podcast, Radley Balco, and even President Obama, who have been kind of reluctant to go there. But they're going there now. I mean, do you see that shift happening?
Definitely. It's definitely happening. You see complete moral collapse of the United States government. The cabinet meeting with 3.5 hours of superficial praise is so cringeworthy. He's attacking the Fed. He's attacking all of our institutions. He's eliminating FEMA. It is horrifying that he is putting troops against American citizens.
Something happened recently in a federal courtroom that almost no one in Washington wants to talk about out loud, but it's forcing some of the most powerful people in the country to rethink everything they thought they understood about this presidency. It started with a single word, a word that judges avoid with extreme caution because of how explosive it is. A federal judge openly described the president's behavior as authoritarian, not in a column, not in an interview, but in a formal ruling that now sits in the official record of the U.S. legal system. That moment alone should have jolted the entire political world, but what happened next was even more unsettling. The judge didn't stop at the president. He directly pointed to members of the president's own cabinet and described them as part of an unconstitutional conspiracy aimed at stripping Americans of their most fundamental rights. When someone with a lifetime appointment, who has nothing to gain politically, uses language like that, the country has to pay attention. And yet, we're watching the political class react like a frog in boiling water, barely noticing just how hot things have become. People close to the administration have been sounding alarms for years, but something has shifted. Even those who used to hold back, people like former President Obama, policy commentators, and institutional moderates, are now speaking with a level of urgency that feels different. The reason is simple. The slow collapse of basic political norms has suddenly gone from subtle to undeniable. You can see it in the cabinet meetings, where senior officials spend 3.5 hours offering hollow praise. You can see it in public attacks on independent institutions, in attempts to discredit the courts, and even in efforts to eliminate entire federal agencies. These aren't normal growing pains of a divided government. They're signs of a system under extreme strain. But nothing made that clearer than what happened in Judge William Young's courtroom earlier this year. His ruling didn't read like a typical judicial opinion. It read like a warning to the entire country. According to court documents, the judge concluded that senior cabinet officials were involved in violating the First Amendment rights of American citizens, not through vague misconduct, but through actions he said amounted to an unconstitutional conspiracy. It's rare enough for a judge to accuse a government official of violating the Constitution. It's almost unheard of for a judge to accuse multiple cabinet members at once, and to place that accusation inside a ruling that could be referenced by future courts, future prosecutors, even future congressional committees. That's a moment that will echo far beyond this news cycle. What stunned legal observers even more was the language he used. Judges tend to avoid broad, sweeping labels. They stick to specific violations, narrow interpretations, cautious phrasing. But Judge Young didn't shy away from describing the president's conduct in terms usually reserved for foreign leaders who undermine democratic systems. It's one thing for a political commentator to throw around a term like authoritarian. It's something entirely different when that word comes from a federal judge. When it appears in a legal ruling instead of a Twitter post or an article headline, it becomes part of the constitutional conversation of the nation. Future courts can cite it. Members of Congress can point to it as justification for investigations. It becomes a reference point for anyone trying to understand what is actually happening inside the government. And just when it seemed like this ruling was already a historic outlier, another ruling landed only days earlier. In a separate case, a different federal judge permanently blocked major parts of the president's voting-related executive order. According to the court's findings, the president had no constitutional authority to rewrite state election rules or link federal funding to compliance with his personal demands. The judge made it clear that the states alone have the power to determine their election policies, and that any attempt by the president to seize that authority was illegal. When two federal judges, in two different courts, within the same week, deliver rulings that accuse the administration of violating core constitutional principles, it's not a coincidence. It's a pattern. And it's growing faster than most people realize. These rulings didn't emerge from nowhere. Over the last several months, courts across the country have repeatedly stepped in to block, reverse, or dismantle various executive actions that pushed past legal boundaries. Each decision adds another brick to a legal barrier forming around the administration. What started as isolated setbacks has grown into a nationwide judicial pushback. It's as if the judiciary has concluded that the usual political guardrails aren't working, and that it's now on the courts to hold the line. When judges begin issuing formal statements that the executive branch is breaching constitutional limits, something shifts in the political equation. Suddenly, it's not just critics or activists raising concerns. It's the judiciary, the branch designed to interpret and defend the Constitution. saying, in measured legal language, that something has gone very wrong. And when the courts take that stance, Washington insiders know the next steps become almost unavoidable. These rulings open the door to conversations that used to sound extreme but now feel unnervingly realistic. Impeachment, the 25th Amendment, and yes, resignation. To understand why those conversations are happening more openly, you have to look at whom the judge mentioned by name. According to the ruling, Homeland Security Secretary Kristi Noem and Secretary of State Marco Rubio were identified as participants in actions that undermined First Amendment protections. When a judge names officials directly, it changes everything. They aren't shielded by political rhetoric anymore. They face personal legal exposure, the kind that can't be brushed off with a press conference or a statement about loyalty to the president. Once their names appear in a ruling describing unconstitutional activity, they have to think not only about their allegiance to the administration, but also about their own futures, their reputations, and their potential liability. History shows that when legal pressure starts closing in, loyalty becomes complicated. Officials who seemed unwavering suddenly begin distancing themselves. Allies start speaking more cautiously. The instinct for self-preservation becomes powerful, especially when a judge has indicated that the behavior in question is not merely improper, but potentially unlawful. And that shift, the emotional and political turning of cabinet officials, is exactly what could set off the constitutional mechanisms the founders left behind. That's where the 25th Amendment comes in. Most people have heard of it, but few truly understand how it works. It allows the vice president and a majority of the cabinet to declare that the president is no longer able to perform the duties of the office. The president can contest it, and Congress ultimately decides. It's a tool designed for extreme circumstances, not casual disagreements. But when cabinet members find themselves implicated in rulings about unconstitutional conspiracies, the conversation changes. They have incentives to act that have nothing to do with political ideology and everything to do with avoiding personal risk. Impeachment is the other mechanism the Constitution provides when a president oversteps the law repeatedly. He's been through the process before, and each time the political landscape allowed him to escape conviction. But now, with judges issuing rulings that describe his conduct as unlawful, and with parts of his cabinet named in judicial findings, the political ground under his feet is shifting. Even some members of his own party have begun to question the wisdom of continuing unconditional support, especially as legal risks grow. But the most interesting scenario, and the one no one wants to say out loud, is the possibility of resignation. It's not a prediction. It's not a guarantee. It's simply one of the logical endpoints when the courts, Congress, and the public all apply pressure at the same time. Remember Richard Nixon? He didn't wake up one morning and decide to leave. The courts cornered him. Congress turned on him. His own party told him it was over. That's how resignation moments happen. They're not dramatic declarations. They're forced outcomes, shaped by political gravity. And right now, the legal gravity is becoming too heavy to ignore. A president cannot be repeatedly declared unconstitutional by the federal judiciary and expect the system to function normally. Cabinet members cannot be named in rulings describing conspiracies against the Constitution without raising the threat of legal consequences. A judge cannot use the word authoritarian in a formal decision without sending shockwaves through the institutions tasked with protecting the country. We're living through a moment that future historians will study carefully. They will point to these rulings as evidence of a constitutional crisis reaching its breaking point. They will note that judges across the country began using unusually strong language, that they identified senior officials by name, that they warned the public in legal terms normally reserved for the most serious threats to democracy, and they will ask whether the people in power at the time recognized the danger quickly enough. What happens next depends on those very people. Cabinet members whose loyalty is weakening, lawmakers who sense the tide turning, and a public that is starting to understand the severity of the situation. The Constitution gives only a few options when a president repeatedly violates the law: impeachment, the 25th Amendment, or resignation under pressure. One of those outcomes is growing closer with every new judicial ruling. The only remaining question is which one arrives first. This moment demands attention, not just from political insiders, but from everyone. Because what's unfolding is not normal disagreement or partisan conflict. It's a structural problem, a clash between constitutional limits and presidential power that cannot continue indefinitely. Something will break. Something must give. And every ruling, every statement, every legal finding adds more weight to the side pushing the system toward a decisive outcome. If this video gave you a new perspective on what's unfolding and helped you understand the seriousness behind the headlines, hit that like button. And if you're not already part of this channel, consider subscribing. It helps more people understand what's really happening far beyond the noise and spin. Share this video with someone who needs to see the full picture, because the mainstream conversation isn't capturing the urgency of this moment. I'll see you in the next one.